It's absolutely nonsense.
I'm sorry, what did you say, sir?
I said this is absolutely different from what we
No,
had
what
the
you
first
said
time.
is this is absolutely nuts, and I don't appreciate it. So unless you want to be found in contempt of court, you should watch what you say in court.
Can I have interpret because I don't understand?
Sir, you've been here so many times,
Yeah, I know.
and you haven't had an interpreter. So I'm not sure why you're requesting one today. If one is requested, you'll be paying for that fee. Do you understand that?
Okay.
Do you want to pay for an interpreter?
Yeah.
All right. How much is it per hour?
I think 115 per hour.
It's 115 per hour, and it's the minimum of 2 hours. So that will be added to your cost. Do you understand that, sir?
Yeah. You said like if you request translate, I'm gonna pay 300.
$330, sir.
Okay, before I have my customer. Okay, no problem because I have to pay a lot of money. If I pay again, he's gonna give me trouble. Okay, I try to understand.
Yeah, you've been here about 6 times since I've been on the bench, and you have not had an interpreter either of those times.
Okay, okay.
Realty and property management versus Lita Boone.
Okay, I'm the owner of the property, and Michael is my property manager.
Yes, I'm here.
Everyone, please state their names.
Joseph Koram, owner.
Lita Boone.
Thank you.
Michael Hannah.
Thank you. All right, this lawsuit, first of all, I'm gonna deal with the legal issue that we have here. This lawsuit is filed in the name of Hannah Realty and Property Management,
Yes,
LLC, is that correct?
say that again, Your Honor.
Limited Liability Company?
Yes, I have the owner on that notice there.
Yes, I didn't ask you that, sir. What I asked is that a limited liability company?
Yes, Inc.
Is it incorporated?
Yes.
Okay. Well, in any event, neither of those are either of you attorneys.
No.
All right. So a company cannot be represented by an individual. You have to have legal counsel in order to proceed with this action.
Okay, well, the owner's on that notice as well, so he can do it himself, can he?
If you want to remove Hannah Realty and Property Management as a plaintiff in this case, and he wants to sue in his individual capacity, he can do that. But right now, that's not what we have.
So it means that I am not party to the case. I'm the owner.
I understand who you are. You've all said that about 3 times. The reality of the situation still remains the same. So right now, this action is not properly before me.
So we should refile in my name. That is what you're saying.
I cannot give you legal advice. You should consult an attorney like I just said.
Your Honor, I went through this before when I was in court, and the judge said long as the owner was on the notice from the beginning, that it was okay to presume.
Then I guess you should go back before that judge, because this judge just said no.
Okay.
But we don't determine which judge we go to.
You're correct, you don't. That is my point. There is but one judge of this court, and that's me. So, do you have any other questions?
No, you're saying that he has to file it himself. That's what you're saying.
Again, I cannot give you legal advice.
Okay.
So the other part of your problem is that the defendant is saying that you have not properly calculated the amounts of rents that she has paid. Did you provide them, Ms. Boone, with a copy of the document that you filed on the court?
No, ma'am.
you need to do that. You can't file anything with the court that you do not file and provide to them.
Okay, I'm sorry, I was misunderstood.
Okay. So do you want an adjournment for the Hannah Realty and Property Management so you can consult counsel?
Say that again, Your Honor.
Do you want an adjournment to talk to an attorney?
Yes.
All right.
It's absolutely nonsense.
I'm sorry, what did you say, sir?
I said this is absolutely different from what we
No,
had
what
the
you
first
said
time.
is this is absolutely nuts, and I don't appreciate it. So unless you want to be found in contempt of court, you should watch what you say in court.
Thank you, madam.
Do the three of you want to talk to see if you can reach some resolution? And ma'am, do you have a copy of the document so you can send it to them today?
I do not have a copy of the document.
Mhm.
I can reprint, and only thing I can't reprint is my letter that I wrote.
In agreement, with all three of us talking, if we could do that, to get some type of resolvement.
I'd rather not. I'd rather just go to court like I asked you, Mike, because it's a lot of things that the judge need to see what our receipts was going on and other things that's going on with us.
Ma'am, I'm going to be very clear with you also. I am going to require that the two of or the three of you talk. So
Okay,
that you see if you can reach a resolution.
okay,
The whole thing that you're talking about in terms of receipts, you don't have it outlined in a way that I can figure it out. So all of you should talk and figure out if there's a discrepancy in the ledger versus what they're saying that you owe. So have that conversation and maybe we can figure out if there's a mistake or if there's not. And if there's not a mistake, they'll at least be able to advise their counsel in terms of where in fact they think that there is a discrepancy and why that discrepancy exists.
okay.
So, do you want 1 week or 2 weeks to speak with someone from legal counsel, Mr. Hannah and Mr. Karam?
1 week. We need to get this resolved as quickly as possible.
All right. If you come back here without counsel or this file being in the proper format, it will be dismissed next time. October 8th, 2025, and I will do it at the same time.
Thank you.
And that'll be 1:15 p.m. via Zoom. We're gonna put the three of you in a breakout room to see if you can reach some resolution. And ma'am, you were advised via the video last week that you should consult legal counsel, and I don't know if you've done that either.
I tried, ma'am. I did. I tried. I
Well, I'm just putting everybody on notice. You won't get additional adjournments for that. Okay,
Okay.
all right, thank you. We're here in this third hearing for non-payment of rent.
Yes.
And it appears that you had filed a notice of rental application for assistance. What
Yes,
is
ma'am.
well, first of all, Ms. Asphalt, have the two of you talked this afternoon?
Yes, we have, Judge, and he's advised me that his application is no longer pending and that we have reached the terms of a consent judgment.
Thank you. You may proceed.
There's currently rent to retain $3,738, costs $175 for a total of $3,913. The defendant is to pay that amount on or before October 13, or a writ can issue. He's given me permission to sign his name to a consent judgment with these terms and file it with the court.
All right, thank you. All right, Mr. Harris, sir, are you aware that you have a right to have a hearing as to the amount of rent that is owed?
Yes.
And you're going to waive that right and agree that you owe $3,913?
I am currently aware that I am 3 months behind with court fees and everything, so that number sounds about accurate.
All right. So, having waived the hearing, then you're going to enter into a judgment for $3,913 that you have to pay by October 13th.
Yes.
All right. If you don't pay it by that date, what happens is they're gonna come back in here and ask me for a writ of eviction, giving you only 24 hours notice to move. Do you understand that part?
Completely understand.
All right. So understanding all of that, sir, I will sign this document. And you will have 3 business days from the date I sign it, to petition the court to set it aside for a really good reason. It is rare that I find that, but you do have the right to file such a petition. Okay?
Understood.
Any questions?
No, ma'am.
All right, then you're all set. Have a great day.
You have a better one.
Thank you. I need that. All right, the court will call the case of Amy Rendy versus Stacy McCullough, case number 25C3644.
Morning, good afternoon, Your Honor. Robert Iggerson on behalf of the plaintiff.
Good
Good
afternoon, Your Honor. Andrew Campbell on behalf of the defendant. My client is present, Your Honor, and I believe Mr. Higreson and I have worked out a deal, a conditional order of dismissal. Is that correct, Counselor? Could you put the terms in the record?
Yes, Your Honor, we've agreed to a conditional order of dismissal. The rent to retain is $8,700. The court costs are $230, total $8,930 through September 30, so that would be yesterday, I guess. Anyway, that's fine. No money judgment at this time. The defendant will have until November 30, 2025 to pay or move out. Counsel, is it okay if I check 4B? No
Yes,
notice.
that's the notice provision.
No notice to be given.
Right.
Okay. And that's it, Your Honor.
Thank you. All right, we have 2 attorneys on this matter, so before I move forward though, is Stacy McCullough present? Could you unmute and state your name, please?
Stacy McCullough.
Thank you. Good afternoon, Ms. McCullough.
Good afternoon.
All right, so I will, of course, sign this particular agreement. There are 2 attorneys that are involved. I presume that you have advocated on behalf of both of your clients and that this is a fair agreement, and I will sign it upon its presentation.
All right, thank you.
Thank you, Your Honor.
Thank you, Judge. Have a good day.
Thank you. You too.
Thank you,
Bye.
Counselor.
Have a good day.
Thank you. And Adam, I'm gonna email that to you now.
Thank you. Have a good day. Thank you.
Thank you. All right, today is the day and time scheduled for this 3rd hearing in this non-payment of rent. She had filed a DC 539 form indicating that she had filed an application for assistance. Mr. Asphalt, I presume the 2 of you had a chance to talk. Could you?
We have the terms of a consent judgment I'd like to put on the record.
All right, before you proceed with that, what is the status of her application, please?
That I do not know.
Okay. All right, she did file a DC 539 form, so I have to ask her about that. But I think it expires today anyway. Right, because her first court date was on September 3rd, so today would have been, today is the expiration of any time frame for that, so she's not entitled to any further stays. You may proceed, Mr. Asphalt.
Thank you. So there's currently rent to retain $2,103, court costs $175, total $2,778. The defendant is to pay that amount by paying $1,017 by October 10 and $1,261 by October 24. If the defendant fails to make either payment, then a writ can issue. She's given me permission to sign her name to a consent judgment with those terms.
All right, what was the second payment amount and what date again, please?
$1,261 by October 24.
So, I think what I'm gonna need from you is the total amount that's due again, because my numbers didn't add up, so.
Okay.
It didn't add up because I paid some off.
Yeah, she made a recent payment, so let me just, okay, so rent to retain is $2,103. Court costs are $175 for a total of, oh, you know what? It's supposed to be a total of 2,278.
All right, thank you. Now that makes more sense. Because I'm like, I can't be that far. All right. All right, ma'am. You first of all, you filed your DC 539 form and requested some assistance, but your time period for that has expired, as I just said. Well, I'm curious, what is the status of it?
Well, they was going off of the court document, so they had asked me to resubmit the one that I paid off because they was going off of the 15 something that the Swan Creek had filed. So they wanted me to resubmit and get a statement from Swan Creek that I paid this amount and this how much left so they can pay the remainder.
All right, so they approved it?
Kind of, sort of. I have to get a statement from Swan Creek to that I owe the 807 because that's what I owe for September. We
All right.
just add in the October end.
Okay. And so, based on what you just said, do you first of all, you understand you have a right to have a hearing as to the amount that's owed?
Yes.
But you're going to agree that you owe $2,278 and waive the right to have any hearing?
I guess I know I owe 807, but we're adding the new rent for October to 1471. So I guess that's right.
Yes, that equals $2,278.
Okay.
So are you waiving your right to have a hearing and agreeing to that number, ma'am?
Yes.
All right. And you're going to pay that as has just been outlined, 1,017 by October 10th, and then another $1,261 on October 24th, correct?
Yes.
As long as you pay it by those days, then I'm asking that they set aside the judgment. If you fail to pay it, though, it'll be on your record, and they're gonna come back here and ask me for a writ of eviction, giving you only 24 hours notice to move. Do you understand that part?
Yes.
All right. Do you have any questions about any of it?
No, I guess not.
All right. You'll have 3 business days from the date I sign this to petition the court to set it aside for a really good reason, okay?
Yes, ma'am.
Thank you. You're all set. Have a good day.
You too.
Thank you. All right, the court will call the case of Country Meadows Apartments versus Nyla Sherrod L. Case number 25C 3611.
Mark Land on behalf of plaintiff.
Nyla Sharadel.
Thank you. Well done. All right, we're here today for the second hearing in this non-payment of rent matter.
Yes.
Yes, Your Honor. Ms. Sharadel and I have agreed to the terms of a conditional dismissal. I had submitted it to your clerk previously, but it has not yet been entered.
I have it. I need you to place the terms on the record.
The terms are that, well, as of September 17, when we submitted the conditional dismissal, Ms. Sherrod L. owed $1,835 and 67 cents in rent, $175 in costs, total is $2,010 and 67 cents, and she was agreeing to pay that by October 6th, along with the October rent and other charges due under the lease that accrued through that date.
Thank you. Is that correct, ma'am? You're gonna pay 2,000 and, so first of all, you're gonna say you have a right to have a hearing as to the amount that's owed, but as of September 17th, you owe $2,010.67.
Yes, that's correct.
You're gonna pay that no later than October 6th, along with the
Yes.
October rent and other charges due.
Yes, ma'am.
Right, I'm signing that as of right now. This case will remain dismissed as long as you pay that. If you fail to pay that, then they're gonna come back and ask for it to be reinstated and us give you 24 hours notice to move. Do you understand that part?
I understand.
All right, you're all set. Have a good day.
You as well. Thank you.
Okay. Are you talking to me? Okay. The court will call the case of Country Meadows Apartments versus Jessica Bakes and Jamari Funderburg, case number 25C 3571.
Mark Lando for the plaintiff.
Jessica Bates or Jamari Funderburg present? If so, please
Yep.
unmute your device, state your name.
Jessica Bates, present.
Thank you. Funderburg here as well, or no?
No, ma'am, she actually had to work today.
Thank you. We're here for the second hearing in this non-payment of rent. Mr. Landau, where are we, please?
Your Honor, Ms. Bates and I have agreed to the terms of a consent judgment. She owes $4,423.80 in rent, $175 court costs, total is $4,598.80, and she's going to pay that as follows. $1,388 by October 17, $500 by October 31, $1,388, which is November's rent on November 1, $500 by November 14, and the remaining balance by November 28. We're also stipulating that she may meet with management to discuss an extension, and if agreed, it must be reduced to writing. And under those terms, she's given me permission to add her signature to a consent judgment. Under those terms, this would be a consent judgment as to her, default judgment as to Jamari Funderburg.
But the same terms apply?
Same terms apply.
And did you put in the language to set aside if they comply with the terms?
I'm sorry, couldn't hear you, Your Honor.
Did you put in the language to set it aside if they comply with the terms of the order?
I did not negotiate that, no.
I'm asking that you put that in, please.
Oh, okay, then I certainly will.
Thank you. All right, ma'am, you understand you have a right to have a hearing as to the amount that's owed,
Yes, ma'am.
but you're going to agree you owe $4,598.80?
Yes, ma'am.
You're going to pay that by paying in the following manner: $1,388 by October 17th, $500 by October 31st, $1,388 by November 1st, $500 by November 14th, and the balance by November 28th.
Yes, ma'am.
As long as you pay according to those terms, it'll be set aside. You failed to, and it's gonna be a judgment on your record, and they're gonna come back and ask me to issue a writ within 24, giving you only 24 hours notice to move. You understand that part? And just so we're clear, is if you miss any of those days, so let's say you pay October 17th, but then you fail to pay October 31st, they can come right in here and ask me for that writ to have you removed.
Okay.
November 1st, okay?
Yes, ma'am.
All right. And that's true for each of the additional payments, right?
Yes.
All right, just want to make sure we're all on the same page.
Yes, ma'am.
All right, I will sign this, and you'll have 3 business days from the date I sign it to petition the court to set it aside for a good cause. It's going to apply the same way to Ms. Funderburg, okay?
Okay.
And you will probably need to notify Mr. Landau's office once if you've paid it off in its entirety, so that they can file the proper paperwork, okay?
Okay. Thank you so much.
You're welcome. Have a good day.
Good, ma'am.
The court will call the case of Fairway Trails Apartments versus Tanya James, case number 25C 3569.
Mark Lando for the plaintiff.
And Tanya James.
Thank you. Well done. We're here on this second hearing for non-payment of rent. She did file a DC 539 form, which entitles her to a stay in this matter. Are you aware of that, Mr. Landau?
Yes, this is the second hearing, so I don't know what the current status is, but we did reach the terms of conditional dismissal, Your Honor.
Yeah, I understand it's the second hearing. That's generally when it begins to apply. So she hasn't had her first 14 days yet, actually. Because her first court date, wait, let me see. Might be true. I might be wrong. Let me see here. So because I was sick last week. Yeah, today would be the 14th day. Ma'am, what's the status of your application?
I believe it's still pending, so I'm not sure. I know they did pay something for my DTE, but it was pending for the rent.
All right. Are you waiving your right to have an additional stay in this particular matter and going to agree to enter into the agreement that you reach with Mr. Landau?
Yes.
So you don't want to stay, you're gonna go forward with this agreement, is that correct?
So what does it actually mean if I don't agree with the I guess if I don't want to stay? So because this is the 14th day now anyways, right?
All right, so the way it works, and I can't give you legal advice, I can only tell you what the law allows. Michigan court rule says that if you file an application, you're entitled to 14 days initially, and then if it's still pending, you can get an additional 14-day stay. But that's where we are.
Okay. So the 14 days has ended though.
The first 14 days did, yes.
Okay. Are you saying that I have an additional 14 days?
That is what I just said, yes.
Okay. I already agreed to terms with the attorney, so the terms that I agreed to are fine.
And you're gonna waive your right to have any additional stay, correct?
Correct.
Thank you. All right, having said that, please proceed, Mr. Landau.
Yes, Your Honor. Ms. James currently owes $2,330 in rent, $175 court costs, total is $2,505. She is going to pay that as follows: $500 by October 15 and the balance by October 27. And this would be under the terms of a conditional dismissal. Paragraph 4B.
Thank you. All right, ma'am. You're going to enter into an agreement whereby you waive the right to have any hearing as to the amount that is owed. So you're going to agree that you owe $2,505, is that correct?
Yes.
All right. And you're gonna pay that by paying $500 by October 15th, 2025?
Yes.
And then the balance by October 27th, 2025. Is that correct?
Yes.
As long as you pay that, then this case will remain dismissed and it will not be on your record, okay?
Okay.
You'll have 3 business days from the date that I sign it to petition the court to set it aside for a really good reason, okay?
Okay.
Do you have any additional questions?
No, that'll be it.
All right, thank you.
Thank you.
Good day.
You too.
We're here on the second hearing for non-payment of rent.
Yes.
I don't see a DC 539 or anything. In case you were wondering, Mr. Landau, you may proceed.
Very good, Your Honor. Mr. Lilly and I met in the breakout room. We've agreed to the terms of a conditional dismissal. And I had actually submitted a conditional dismissal earlier, but we're going to tweak the terms of it at this point. Mr. Lilly currently owes $2,870 in rent. $175 are the court costs. The total is $3,045. And he's going to pay $1,000 by October 13 and the balance by October 31. This will stay as a conditional dismissal, and it's under paragraph 4B.
So defendant shall pay the $3,045 by paying $1,000 by October 3rd, along with October rent and other charges due will be due by the end of October 31st, 2025. Is that correct?
Not October 3rd, October 13th.
October 13th.
Yes.
Thank you. All right.
So just to get correct, I'll pay $1,000 by the 13th, and then the remaining of the balance by the end of the month.
Yes, October 31st. Correct.
Okay, and I don't want to keep on asking for changes of the terms, but I was just checking my payment schedule, and I wouldn't get the check for the final balance until the 7th, and because I get paid on the 10th and then the 24th, and then 2 weeks after, which would be the November 7th. So I'm asking, can I probably extend it from the 31st to November the 7th to pay off the balance?
It sounds like, Mr. Landau, the two of you need to talk a little bit further.
We can go back into the breakout room and chat some more.
Yeah, thank you. That's what we'll do. I'll pass that. Oh, I see.
Same breakout room?
Yes. Yeah, I think she's gonna send you directly. And are you? All right. You ready now?
Yeah.
All right, the court will call the matter of Jomar Realty versus Diane Joyner, case number 25C 3596.
Good afternoon, Your Honor. David Fantera. I got to think of what time of the day it is. You know, those 7:30 meetings just throw everything off.
They do.
Good morning, Your Honor. David. Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Thank you. Good afternoon. Ms. Joyner,
Good afternoon,
please state your name for me. Good afternoon.
Diane Joyner.
Thank you. All right, we're here for this third hearing in this non-payment of rent matter. And she did file a DC 539, which she has one more week on, depending on whether the status of the application, obviously.
Well, I think what we've decided to do is her balance, including October, is $3,459. She's going to pay $1,000 before next Wednesday. And what she really needs is a payment plan that goes out into December. And I told her if she made the $1,000 payment before next Wednesday, and I guess, by the way, I'm asking, we adjourn the case till next Wednesday. And if she does that $1,000, then I'm going to give her the payment plan, which she needs. And I've taken her phone number, and I told her I'd call her on Tuesday. And that if she doesn't make the $1,000, then I'd be coming back and asking for a judgment. And I think what I just said is acceptable to her.
That's correct. All right, thank you. I'll adjourn this over to October 8th at 2:00 p.m. then. And then we can hopefully have you had paid that $1,000 and we'll be all set.
You said 1 p.m.?
2 p.m. now.
2 p.m.
Yes.
Okay.
All right, thank you.
Thank you.
Have a good day. Court will call the matter of 922 Homes versus Alan Martin, case number 25C 3667.
Your Honor, David Fantera on behalf of the plaintiff. Mr. Martin texted me and said that he was having trouble going into the breakout room. So I've got a couple more cases here. If we could do those, and then maybe Mr. Martin and I can go in the breakout room. But it's also my understanding that he has a 539 form also. Where does he stand on that? Because he texted me, I mean, maybe we don't even need to go in the breakout room. He texted me and said he applied for assistance, waiting to hear back.
Yeah, he just he filed it on September 23rd, which was timely. It's this last date I filed it, I think. Anyway, he did file it. And if his application is still pending. Mr. Allen, are you present?
Yes, I'm here.
Right, please. So, sir, is your application still pending?
Yes. See, I have 2 applications out. One with Department of Human Services and one with Hawk Hawk had told me they're waiting to see if they get funding later, but I'm gonna try to submit a payment this week and follow through because they told me, it's still up in the air. But DHS, I'm still waiting to hear back. But they approved half of my SER for my utilities, but I'm waiting to see back for rental assistance.
Your Honor, may I?
You may.
So he would be entitled to 2 more weeks, right? Am I correct?
That is correct.
So my thought would be, I would encourage him to make that $600 payment.
Okay.
I would ask that the case be adjourned not for 1, but for 2 weeks. And then when we come back on the 15th, basically that would end his stay, no matter where he stands with SCR. I think what he told me was that he would need till the end of the month to get it paid, and I'm certainly willing to do that if he makes that $600 payment. So, Your Honor, I'm requesting that we adjourn the case for 2 weeks. He make the $600 payment, and then we'll deal with it when we come back on the 15th.
October the 15th, 2025 at 2:00 p.m. We'll see you then, sir. Please make that $600 payment so you can be in the best position possible so that you and Mr. Fantera can work this out. And hopefully you'll have some assistance by then as well.
I appreciate it.
And let me just add this to Mr. Martin. From what we heard today, the Hawk's not going to have money until sometime in November. So if you're counting on that, probably not something you're going to be able to count on at this time.
Okay.
Go through with your appointment. Go have the appointment, but always have a backup plan.
Okay. Yeah, they gave me other resources for Friends Indeed and all that and stuff. So I'm gonna see what I can do.
All right, cool. Thank you.
Thank you.
All right, have a good day.
You too. Bye.
Laurel Bay Apartments versus Melvin Lilly, 25C, 3565.
Mark Lando again for the plaintiff.
Melvin Lilly.
Thank you. All right, Mr. Landau, the two of you had a chance to talk further, or are we, sir?
We did, Your Honor, and we're going to stick with the agreement that was previously placed on the record. If you'd like me to restate that, I will.
I don't need you to restate it. The total was $3,045, which included $2,870 in rent and $175 in court costs to be paid $1,000 by October 13th and the balance by October 31st.
Right.
Yes.
And so, sir, you're going to waive a right to have a hearing as to any amount that's owed, and that is the agreement that you're going to reach, and it's going to be a conditional order of dismissal, meaning this case will be dismissed if you comply with that agreement. If this case is dismissed, as long as you comply with that agreement, it remains dismissed. If you fail to comply, then they're going to ask me to reinstate the case and give you only 24 hours notice to move, okay?
Yes, I understand.
All right, do you have any questions about any of that?
No, not at this time.
All right, then I've mocked up this old document. You're free to send in a new one, or we can just use this one that we have here. I will sign it and then it'll be all good to go if you want, Mr. Landau.
I'm good to go with you signing that document, Judge.
Thank you. I have signed it and you're all set.
Thank you, Judge. Have a great day.
You too. Bye-bye.
You have a good day, Judge. Hopefully
You
don't
too.
have to see you again. No
Thank
more.
you. I hope that's true for you too, because I know it's not a pleasant experience. So I get that. Thank you. Bye-bye. Bushwood Properties LLC versus Cassandra Wise and William Bryant, case number 25C 3665.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Good afternoon again. Cassandra Wise, if you're present, please unmute your device and state your name.
William Bryant.
William Bryant. Hello, Mr. Bryant.
Hello.
All right, we're here on this second hearing for the non-payment of rent.
Yes, and this will be a consent judgment as to Mr. Bryant, a default judgment as to Ms. Wise, same terms otherwise. The amount of rent that's owed is $3,250, court costs of $188 for a total of $3,438. We've agreed that that amount has to be paid by October 31st, or they could be evicted. I emailed him a copy of the judgment. He reviewed it, gave me permission to sign his name. Judgment will be set aside if paid, and I advised him of his rights under the court rule.
You say a total of $3,348?
3438.
Thank you. All right, sir, you have a right to have a hearing as to the amount of rent that is owed, but you're going to agree that you owe $3,438 and waive any hearing as to that amount?
Yes, Your Honor.
You're gonna pay that no later than October 31st, 2025?
Yes.
If you pay it, it'll be set aside, meaning you won't have this judgment on your record, but if you fail to pay it, then they're gonna come back here and ask me for 24 hours notice to give to you to move, sir. You understand that part?
Understood.
You're all set, Mr. Bryant. You have 3 business days from the date I signed. Petition the court to decide for a really good reason. So you're all set. Have a good day.
All right, you do the same.
Thank you. Jomar Realty versus Stephen Adolph, case number 25C3134.
David Fanter on behalf of the plaintiff.
Stephen Adolph.
Thank you. All right, we're here today for this 4th hearing. Last time we were here, he had an appointment with Hawk. Probably know how that turned out, but I guess he could be one of the few that we talked about today. So where are we with this case?
Your Honor, in this case, there's rent owing in the amount of $2,962, court costs of $162 for a total of $3,124. We've agreed that that amount has to be paid by October 31st, 2025, or he could be evicted. I emailed him a copy of the judgment. He reviewed it and gave me permission to sign his name. Judgment will be set aside if paid, and I advised him of his rights under the court rule.
So you understand the right to have a hearing as to the amount that is owed?
Yes.
You're going to agree that you owe $3,124 and you're going to pay that no later than October 31st?
Yes.
As long as you pay it, then it'll be set aside. You fail to pay it, and it's going to remain on the record, and they're going to come back in here and ask for a writ of eviction, giving you 24 hours notice to move. You understand that part?
Yes.
All right. You'll have 3 business days from the date I signed this petition report to set it aside for a really good reason. Okay?
Okay.
You're all set. Have a good day.
Thank you too.
Thank you. All right, the cold call the case of Timberlands versus Candria Roberson and Rodri Rendelman, case number 25C3513.
Christopher Asfalk on behalf of the plaintiff.
Thank you. Rodri Rendelman, are you still present, sir?
Yes, I am.
Please state your name for me.
Audrey Rundelman.
Thank you. We're here for this 3rd hearing for non-payment of rent.
Yes, Judge, we have a consent judgment I'd like to put on the record.
All right, you may proceed.
All right, I spoke with Defendant Vodri Rendelman, and we are in agreement that there's rent to retain in the amount of $910, cost $214, total $1,124. The defendant is to pay that amount on or before October 13, or a writ can issue. She's given me permission to sign her name to a consent judgment with those terms. I would request entry of a default judgment for the same terms to the non-appearing defendant, Kendria Roberson.
So Rodri, I thought was a male. Is that correct?
Yes.
All right, thank you. So Mr. Rendelman, you gave him permission to sign your name?
Yes, I did, Your Honor.
Right. So having said that, you understand you have a right to have a hearing as to the amount of rent that is owed, is that correct?
Yes, Your Honor.
You're gonna waive that right and you agree you owe $1,125 in total, including court costs, correct?
Yes.
All right. You're gonna pay that no later than October 13th, 2025?
Yes, Your Honor.
All right, as long as you do, then I'm asking that it be set aside and not on your record. If you don't pay it, then it'll be on your record and they're gonna ask me to give you 24 hours notice to move. Do you understand that?
Yes, I do.
All right. Mr. Asphalt, you're putting that language in there about the set aside, correct?
Yes.
All right, thank you. You'll have 3 business days from the date I sign this to petition the court to set it aside for a really good reason. You're all set. Have a good day.
You too. Thank you.
Thank you. I will call the case of Lake Point Trafalgar Limited versus Beverly Jackson, case number 25C 3603.
Good afternoon, Your Honor. Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Good afternoon, Ms. Miller.
Beverly Jackson present.
Thank you. All right, we're here in the second hearing for non-payment of rent.
Yes, we have a consent judgment to put on the record.
All right, thank you. Give me 1 minute. All right, you may proceed.
Yes, we've agreed that there's a total of $3,803 owed in rent, $168 in court costs, for a total of $3,971. This is a possession case only. Ms. Jackson has agreed to pay $2,000 by October the 13th, 2025, and the balance of $1,971 by October 31st, 2025. And she did give me permission to sign her name and electronically submit it to the court.
Thank you. All right, ma'am, you understand you have a right to have a hearing as to the amount of rent that is owed. But you're going to waive that hearing and not have a hearing and agree that you owe the $3,971 total, including court costs?
Yeah.
And you're gonna pay that in the following manner: $2,000 by October 13th and a balance of $1,971 by October 31st.
Yeah.
As long as you pay that, then it'll be set aside. I'm asking that to be written on order. If you fail to pay it, or either one of those, if you don't comply with this, then you'll have a judgment on your record, and they're gonna ask me to give you 24 hours notice to move. Do you understand?
Yeah.
All right. Thank you.
Thank you so much.
You're welcome. You have 3 business days from the date I sign it, which is likely to be today based on how Ms. Cohen operates. She'll submit that as soon as she gets off the phone, and I'll sign it today. You'll have 3 business days. Petition to set it aside for a really good reason. It is rare that I do that though, okay?
Okay, thank you.
You're all set. Have a good day. You're welcome.
Bye.
Thank you. Have a great day.
You too, Ms. Cohen. Okay, we're gonna let in a couple phone numbers to find out who they are. All right, we just let a phone number that ends in 6,000. 6000 are your last 4 digits. Could you please unmute your device by hitting *6 and tell us what your first and last name is?
My first name is Esther. My last name is Glaze.
1 moment. All right, we found you. We will put you in a list of cases to go into a room with an attorney. All right, you're going in with an attorney from McKinley, so you'll be on a list of cases. So please just don't hang up. Hold on, you'll go in automatically and we'll take care of it. It may take a while. You don't have to ask about it again. We do have you, okay?
Okay.
Thank you.
Thank
you. All right. Okay. There's a phone number that, I'm sorry. Okay, ends in 6337. 6337 are the last 4 digits of the phone number. 6337. Please unmute the device and tell us your first and last name.
Kevin Dozier.
Kevin Dozier. Thank you, Mr. Kevin Dozier. Right, you're going into a breakout room with Mr. Fantana right now. Mr. Fantana, you could go back into your room. We'll send him right in with you.
Thank you.
Okay.
Okay. All right. All right, there's a device labeled iPhone that was just allowed into the breakout room. Ma'am, could you please unmute that device and tell us your first and last name? I'm sending you a button to unmute. Please hit it.
Yeah.
Right, what is your first and last name, please? You muted yourself.
Latanya Jones.
Thank you, Miss Latanya Jones. Give me one moment.
Okay.
See that, Miss Jones? Do you have a case number?
Hold on.
I'm sorry?
Hold on 1 second.
1 second, please, Miss Jones.
Okay.
For 215, Your Honor, but a dismissal was filed on Ms. Jane's matter.
All right, your matter has been dismissed, ma'am, so you don't need to be here.
Okay, thank you so much.
Good day.
You have a blessed day.
Thank you, I appreciate that.
Thank you.
Want to let in Zoom user?
Yep, I'm letting them in right
All
now.
right. There's a device labeled Zoom user that was just allowed into the virtual courtroom. Could you please unmute your device and tell us your first and last name?
Mbanjo.
Oh,
Thank you. Mr. Bangu, you're going to be going into with the attorney from the Fink Law Firm, and you'll be in the list of cases to go in. You'll go directly in. Please do not leave until you've gone in and your case has been called.
Can I have a can I have interpret because I don't understand?
Sir, you've been here so many times
Yeah, I know.
and you haven't had an interpreter. So I'm not sure why you're requesting one today. If one is requested, you'll be paying for that fee. Do you understand that?
Okay.
Do you want to pay for an interpreter?
Yeah.
All right. How much is it per hour?
I think 115 per hour.
It's 115 per hour, and it's the minimum of 2 hours. So that will be added to your cost. Do you understand that, sir? Mr. I understand that. Do you understand that, Mr. Mbango?
Yeah. You said like if you request translate, I gonna pay 300.
$330, sir.
Okay, before I have my customer. Okay, no problem because I have to pay a lot of money. If I pay again, he gonna give me trouble. Okay, I try to understand.
Yeah, you've been here about 6 times since I've been on the bench, and you have not had an interpreter either of those times.
Okay, okay.
All right. I'll pass this. You'll go to the breakout room when the time comes.
Okay, thank you.
This is David. All right, the court will call the matter of Bill Properties LLC versus Jessica Linton, case number 25C 3361.
Good afternoon, Your Honor. Gabriel Lacey for Bill Properties.
Good afternoon.
Good afternoon, Ali Bazarian and my partner Ethan Cherry on behalf of Jessica Linton. Permission to speak pursuant to Michigan Court Rule 8.120 under the supervision of Sarah Salem.
Permission is granted.
So
Judge,
we wanted
for the
to-
record, Sarah Salen from the Michigan Civil Criminal Litigation Clinic. Thank you.
Thank you.
So we wanted to seek a court order to have their client submit a landlord packet to Section 8 for our client because the lease was not submitted correctly, and communication between their client and Section 8. We spoke with opposing counsel and they agreed, so.
I am not opposed to such an order. I have already emailed the client regarding what's necessary, and they have responded only for when they are moving. We just moved them into their current unit. I don't know. If I can share this with the court, they're looking for like the lease packet when the client moves into a new unit. Is that correct?
That's correct.
Okay.
And I will indicate for you that we were here back on September 17th. And at that time, we addressed that issue. And I had indicated that that landlord packet needed to be provided.
I understand that, Your Honor. And all I can say is I am actively in the middle of doing it right now.
So, in terms of an order, if that is necessary, I will certainly sign one, indicating that. And then what are we going to do today in terms of a next hearing?
We're just gonna adjourn. If I may again, Sister Counsel, you need the packet from what month? March of this year?
It should be April.
April of this year. Okay. I just
And I
want to make
can-
sure I get it right, Your Honor. I'm sorry.
No, you're fine. That's not directed at you. Sometimes my head actually itches. You know that, right?
Well, I think Your Honor caught me doing one of these, so.
So yeah, there's that.
And I can re-forward also the lease that should be included in that.
Okay, thank you. I appreciate that. All right, they are working on it. I have given them clarity. So hopefully by the time we're back, we have what's necessary, and I will continue to follow up.
And did you say 2 weeks or 1 week?
I'm
2
fine with 2 weeks is fine.
All right, we'll see you all back on October the 15th, 2025. Let's do it at the same time, 2:15 p.m. That way we can always sort of think about it that we show up here at 2:15 and we get heard whenever that can happen. All right. See you on
Thank you, Your
October
Honor.
15th, 2025.
Thank you.
We'll call the matter of Village Grow 1 LLC versus Maureen Davis, 25C 2793.
Gabriel Lacey for Village Grove.
Maureen Davis.
All right, we're here on this fifth hearing for a non-payment of rent. Defendant was gonna pay $1,040.
That is correct, Your Honor, and she has confirmed that she has made that payment. She did some of it on the portal and the other, she walked in a certified check of $440. Because it was so late in the month, I don't have it reflected on the letter that was sent over to me, but I did put in our consent judgment that the defendant paid $440 on 9/26/25, and it will be credited upon a verification. So the 440 is not reflected in this judgment amount.
So you're indicating that you're entering into a consent judgment. What is the total amount that is, what is the amounts that are owed at this time?
So right now, the outstanding rent to retain is $4,785. Court cost of $175. Total balance is $4,960. And we have agreed on a pay or vacate date of October 20, 2025. And again, that 440 is down on line 10 to be credited upon verification. I did advise over rights under MCR 4.201 subsection J.
Thank you. All right, ma'am, you understand you have a right to have a hearing as to the amount that is owed. You're gonna waive that right and agree that you owe $4,960 even?
Yes, Your Honor.
And you're gonna pay that on or before October 20th, 2025, or vacate by then?
Yes.
As long as it's paid or you vacate. And did you put in the to be satisfied piece? Ms. Lacy?
I'm sorry, Your Honor.
You put in this to be set aside if she complies.
Yes.
Okay, to be set aside if you comply, you all get a $440 credit if they can verify that you actually paid that. Okay. You have 3 business days from the date I signed
Yes.
the agreement. The petitioner clerk to set it aside for a really good reason. Okay.
Okay.
You're all set. Have a good day.
Okay, thank you.
Welcome. Can you just ask them to bring the files back, please? We'll call the case of Beal Properties LLC versus Bitimi. Ooh, boy. Ogbuzulu, case number 25C 3734.
Gabriel Lacey for the plaintiff.
Sir, please unmute your device and state your name.
The name is Ebitimi Alexander Ogbuzulu.
Thank you, sir. All right, we're here in the second hearing for non-payment of rent.
Yes, thank you, Your Honor. At this time, we have agreed on a consent judgment where the defendant owes $4,509.40. Court cost of $175. Total outstanding balance is $4,684.40. Under the court further orders, the defendant will pay monthly rent through Flex Pay Timely and an additional $500 on the 16th of every month until the balance is paid in full. And that starts this month on the 16th, October 16th. Defendant waives the 56-day rule in consideration of the extended payment plan. I did advise him of his rights under 4.201 subsection J.
And you said this is going to be a consent, or what did you say in terms of the
I
type?
did. It's a consent judgment, and I'll add the language that it'll be set aside if he complies.
All right, so you understand that you have a right to have a hearing as to the amount of rent that you owe?
Yes, I do.
And you're going to waive that hearing and agree you owe $4,684.40 in total?
Yes, I do.
And did you hear the schedule that was just outlined in terms of how it's gonna be paid?
Yes, I did.
And are you gonna pay it according to that schedule, sir?
Yes, I agree.
If you miss any of those payments, they can come back in here and ask for a writ of eviction, giving you only 24 hours notice to move. You do understand that?
Yes, I do.
Hmm. I'm gonna sign this agreement. You have, and you understand you're giving up the right to have 56 days for them to tell you need to move, because that needs to be waived in order for you to have this extended payment plan. You understand
Yes, I
that?
do.
All right.
Yes, sir.
So you're gonna have 3 business days from the date I sign this agreement to petition the court to set it aside for a really good reason, okay?
Okay.
All right, you're all set, sir. Have a good day.
I wish you a beautiful one. Thank you.
Well, I appreciate that. 1 second, please. All right, the court will call the case of Bill Properties versus Olajuwon Thorell, case number 25C 3630.
Gabriel Lacy for Bill Properties.
Olajuwon Thorell here.
Thank you. We're here for the second hearing in this non-payment of rent matter.
Thank you, Your Honor. I have had an opportunity to speak to Mr. Thorell, and we have entered into a consent judgment where the outstanding rent to retain possession is $1,397, court cost of $175. Total outstanding balance is $1,475.97. We've agreed on an extended writ date of October 15th, 2025 to pay that amount in full. I have advised him of his rights under MCR 4.201 subsection J, and have written under the court further orders this judgment be set aside with timely payment.
Thank you, sir.
Or
You
compliance.
understand you have a right to have a hearing and compliance, definitely. You understand you have a right to have a hearing as to the amount of rent that is owed?
You talking to me? Yes.
Yes, I'm talking to you, sir. Mr.
Okay.
Thorell. You
Yeah.
agree that you're going to waive that hearing and you're going to pay that amount of $1,475.97. You're going to agree to that number and pay it by October 15th, 2025?
Yes.
And as long as you pay it by then, it'll be set aside. If you fail to pay it, then it will not be set aside, but they'll be asking me for a writ of eviction to give you 24 hours notice to move. You understand that part?
Yes.
All right.
Oh, wait. So if I pay like most of it, and not most of it, but like the rest of it that Friday and like that 15th, is that okay?
You have to pay it by the October 15th date, sir, or they can come and ask for a writ of eviction.
Okay.
Okay? If you pay it October 15th, then it'll be set aside and it won't be on your record. Okay?
Okay.
All right. You'll have 3 business days from the date that I sign this petition to court to set it aside for a really good reason. Do you understand that part?
Yes.
All right. You're all set, sir. Have a good day.
You too. Thank you. Don't work too hard.
Yeah, I wish that was the way it worked. Take care. Bye. Bill Properties versus Carlos Hicks, 25C 3762. Do you guys notice how people always say that when their case is done? Because it only, when they're done, then they don't want me to work hard on the rest of you guys' cases.
Gabriel Lacy for Bill Properties.
All right, Mr. Hicks, please state your name.
How you doing? My name is Carlos Hicks.
Thank you. I'm fine, Mr. Hicks. All right. We're here today on this.
So, Your Honor, this is a transfer case, and I am hoping that, well, maybe I shouldn't say hoping, but I do believe that Mr. Hicks needs the assistance of legal aid in this matter.
Oh, okay. Is anyone here from legal aid that can talk to him, or you guys don't do that anymore? I don't know if anyone's here anyway. Yeah, I don't see anybody here. So do we want to adjourn it for a week so he can talk to them? Is that
Please, if the court can give him the contact information for legal aid, and we'll adjourn for a week.
All right, Mr. Hicks, I'm gonna adjourn for 1 week so that you can talk to legal services. So in this particular case, sir, you were before Judge Simpson on this case? Did he go over,
Yeah.
he went over your rights with you already, right?
No, he never ran off my rights. It was really quick.
Did you watch a video?
No, I'm talking about video before you get to court.
The video after, at your first hearing, sir?
No.
Okay. Well, this court has a video. It's online at the 14B District Court.
Okay.
I'm gonna need you to go online and watch that video. You should watch that this afternoon, once you get off here. You
Okay.
need to understand what your rights are with respect to this case. And it sounds like you should talk to legal services, and I'm gonna give you their phone number, okay?
All right.
You have a pen to write it down?
Let me go find one. Can you give me 1 second, please?
Sure.
I'm Rick. Let me. I can't find a pen right now, so let me just put it in my notes on my phone.
Okay, you have your notes pulled up?
I'm pulling it up right now. All right, I'm ready.
All right. So the phone number is 734.
7. Oh, give me 1 second. My phone be glitching sometime. Okay.
665.
Okay.
6181, legal services. Call them, start calling them immediately, okay? Because when
Okay, I will. And then I have a question. What happened if I can't get, last time I talked to legal aid, they said I can't do it in person. So I called them, and then if I can't get a response to them and by a week, what do you want me to do if I can't get a response from them?
I need you to keep calling them until you get a response from them. And if you don't hear a response from them, after you can document that you keep calling them, call Miss Lacy and let her know that you can't reach them. And hopefully the two of you can figure something else out. The other thing is you can call the U of M legal clinic. Have that phone number in front of me.
Okay, give me 1 second. I'm gonna put another notes.
God bless you.
Thank you. Actually, call the clerk's office there and ask them for the phone number for the U of M legal clinic. Do you have, you don't have it either, do you? I don't have it. I'm not at my normal desk. Well, my permanent desk, and I don't have all the stuff I usually have at that desk. I don't have the U of M legal clinic number up here. So can you call to the clerk's office and ask them to give you the University of Michigan legal clinic number, so that if you can't reach legal services, maybe the U of M clinic will talk to you. Okay?
Okay, then, thank you.
You're welcome, and I'll see you back here on October 8th. And
what time is that?
I'm gonna just give you that in one moment. I'm gonna make that at 1 second. We'll make it at the same time, 1:15 p.m.
Excuse me, that's not, I have a court date, like I have a in-person court date that actually day at 9 o'clock, so I won't be able to make it on Zoom. So can you reschedule for another day?
No, I can't schedule it for another day. I can schedule it for later in the day. What kind of hearing do you have?
It's a criminal, it's a criminal case.
Pre-trial, or what is it, sir?
It's a pre-trial.
Yeah. I'll schedule it. They have to be back here at 3 o'clock anyway. So I'll schedule it at 3 p.m. You should be done with your pretrial by then. I'm certain that whichever judge that is will not be on pretrials at 3 p.m. Okay?
Okay, then. Thank you.
Yes, you're welcome. We'll call the case of Bill Properties versus Titha Billups, case number 25C 3556.
Yes, I'm here.
Gabriel Lacey for Bill Properties.
Thank you. Please state your name, Ms. Billups.
Tessa Billups.
Sorry, ma'am. All right, we're here for this third hearing on this non-payment of rent matter.
Yes.
Thank you, Your Honor. I have had an opportunity to speak with Ms. Phillips in the breakout room, and we have entered into a consent judgment where she agrees that the rent to retain possession is $2,285. Well, actually, no, Your Honor, it's not. I got to fix it. I fixed it on my note page. The rent to retain possession is $1,437. Court cost of $175, and I just did that backwards. The total is $1,437. Court cost of $175. The rent to retain is $1,262. Those are the numbers.
I am
Without,
so confused right now.
I
What's
know.
the total?
So Section 8 has, or the housing
No,
department
I
hasn't.
just want to know the total number, please.
The total number, Your Honor, is $1,437.
Right. Thank you.
So sorry about that.
That's okay.
But we've agreed on a payment plan where the defendant will pay $500 on the 3rd of every month until the balance is paid in full. Her last payment will be January 3rd, 2026. The defendant, in consideration of the extended payment plan, waives the 56-day rule. The late fees will be waived with timely payment and the judgment to be set aside with compliance.
Thank you. All right, ma'am. So just so we're clear, the amounts that she's paying include from those amounts as well.
Yes.
Okay. So, ma'am, you have a right to have a hearing as to the amount that is owed. You're going to agree that you owe $1,437 at this point?
Yes, I am.
And they're going to you guys came up with a payment plan whereby you're going to pay $500 on the 3rd of each month until your balance is paid in full?
Yes.
That means your last payment will be on January the 3rd of 2026?
Yes.
And that will include whatever amounts you owe for each month, correct, until that time period. So you're
Yes.
paying your rent for those months and catching up at the same time, which makes it the $500 each month.
Yes.
Right?
Yes.
Okay. All right. I will sign this agreement and you'll have 3 business days from the date I sign it to petition the court to set it aside for a good reason. You understand you can't miss any of those payments. If you miss any of those payments, they can come in here and ask me to give you 24 hours notice to move. You understand that?
Right. So as I'm paying my rent and late fee, so it'll all be $500 every month. Okay. Yes. Yes, I agree.
All right. Thank you. You're all
Thank
set. Have a good day.
All right. You have a nice day.
Thank you.
Thank you.
What we'll call the matter of the Ranches of Rosebrook versus Kevin Dozier, case number 25C 3443.
Good afternoon, Your Honor. David Van Care on behalf of plaintiff.
Kevin Dozier.
Thank you. We're here for this 4th hearing in this non-payment of rent matter.
Yes. We've come to an agreement. The amount of rent that's owed is $2,051.84. Court costs of $177 for a total of $2,228.34. We've agreed that that amount has to be paid by October 21st, 2025, or he could be evicted. I emailed him a copy of the judgment. He gave me permission to sign his name. The judgment will be set aside if paid, and I advised him of his rights under the court rule.
Thank you. Understanding that, the Mr. Dozier, you understand?
Yes.
You'd like to have a hearing as to the amount that's owed,
Yes, I understand.
but you're gonna waive that hearing, agree that you owe $2,228.34.
No, I'm not gonna waive it. I understand that we'll have to pay it.
Okay, waive it means you're not gonna have it, means you're gonna give up your right to have it. So you're gonna waive it and not do that.
Oh, yeah, yeah.
Okay.
Yeah, I'm saying yes, yes.
Okay, and then you're going to pay that $2,228.34 by October 21st, 2025, correct?
Correct.
All right. If you pay it,
Correct.
set aside. If you fail to pay it, then it'll remain on your record, okay?
Okay.
All right, you'll have 3 business days from the date I submit the petition to court to set it aside for a really good reason. If you fail to pay it by that date, they can come back in here and ask me to give you 24 hours notice to move. You understand that part as well?
Yes.
You are all set. Have a great day.
All right, thank you.
Thank you. Oak Ridge Apartments versus Kiwana Butler, case number 25C3402.
Yes, Christopher Asphalt on behalf of the plaintiff.
Thank you. Hello again, Ms. Satchwell.
I'm also present, Kiwana Butler.
Thank you. Hello, Ms. Butler. Today's day and time scheduled for this third hearing in this non-payment of rent matter. Ms. Butler did file a DC 539 form, but her time limit expired today. So you may proceed, Ms. Aswell.
Your Honor, we have a consent judgment. The terms are as follows. There's rent to retain in the amount of $1,636.88, court costs of $175 for a total of $1,811.88. The defendant shall have until October 15, 2025 to make that payment, and she's given me permission to sign her name to a consent judgment with those terms and file it with the court.
Thank you. All right, ma'am, you understand you have a right to have a hearing as to the amount of rent that is owed.
I do understand that.
You're gonna waive that right and agree that you owe $1,811.88 in total. You're muted if you're saying anything, ma'am. You're still muted.
Yes, I'm waiving the right to a hearing for that amount, but I also wanted to make sure that we had the exact thing on record that we talked about in the breakout.
Okay, which is that you pay it by October 15th, 2025, or something different?
It was that plus the additional statement that if I were to pay an amount prior or amount below that amount, at least by then that
I'm sorry, I didn't catch all of what you said.
management to extend the time.
So
It was that statement with the addition of if I were to be able to come up with something less than that by the 15th, that perhaps I might be able to work something out with the property manager. So that leaves me with the impression that I have to pay that by then, but there is some wiggle room in case. I don't understand how that's interpreted by the court, basically.
There is no real interpretation by the court. So what that means for you, ma'am, is you've reached an agreement in court that says you have to pay it by October 15th. If they choose to give you anything in addition to that, that is completely up to them. And it is only a perhaps or a maybe. And there is no guarantee that that is going to happen. And there's nothing enforceable here in court.
Right, I know, but I'm saying if that were the case, would some further steps then be put on by the management to you guys to change this, or do I have to, how does that work?
Nope, the court is done after today, ma'am. That would be between the two of you if you reach any agreements.
Okay.
Do you want to talk to Mr. Asphalt again, or what do you want to do?
Yes, ma'am, I would.
Okay. We'll put you two back in the breakout room.
How are you?
I'm doing good, and yourself?
I'm fine. I'm talking to an organization right now, and they're going to be helping me with it. They just want to know the outcome of this, what this is going to be, so I can let them know. and they want me to give them a call first thing in the morning, or it's supposed to be right after this court. But it's a organization called Peace Neighborhood, and they're going to be helping me.
I'm not understanding.
What do you mean?
Am I speaking with the judge?
No, this is Raven. Why am I am I supposed to be in the breakout room?
I'm not for sure.
Okay, let me go back to the thing then. I don't know how I ended up here. This is Raven Nobles. Am I supposed to be talking to you?
I don't know. Your name doesn't sound familiar.
Okay, yeah, I'm gonna go back.
Everyone should be muted at this time, please.
I'm confused. Okay, I'm sorry.
We're here for this third hearing in this non-payment of rent matter.
Yes, Your Honor, in this case, there's rent owing in the amount of $4,010, court costs of $162 for a total of $41.72. Ms. Sizemore indicates that she is moving out, and that she can be out by the 14th. I emailed her a proposed judgment. She gave me permission to sign her name. Judgment provides that it'll be set aside if she complies with it, and I advised of her rights under the court rule.
So, what is she complying with? I'm sorry, is she
She
paying by
either pays or moves out.
what date, please?
Yes,
By which date to pay or move?
by October 14th.
By October. So ma'am, if you pay or move by October 14th, so first of all, you have a right to have a hearing as to the amount of rent that is owed. Do you wish to agree that you owe $4,172 and not have a hearing?
Yes.
And you're going to pay or move by October 14th, 2025, correct?
Correct.
If you do, it'll be set aside and you won't have a judgment against you. If you fail to do either one of those two, they're gonna come in and ask for a writ of eviction, giving you only 21 days to move, okay?
Okay.
Wait a minute, you want to?
I'm sorry.
You said 21 days to move. You
I
mean
did say
24 hours?
I'm completely wrong. 24 hours notice to move, okay?
Okay.
All right, thank you. Sorry.
Thank you.
And I won't bother saying have a great day, so.
Thank you. It's gonna be a long day, and I don't know how I got so distracted, but I just did. I'll try to be more focused.
No, you're always great. Thank you. Have a great day, Your Honor.
You too. Bye-bye. All right, the court will recall the case of Oak Ridge Apartments versus Kiwana Butler, case number 25C 3402.
Christopher Asphalt for the plaintiff.
I'm present.
Please state your name.
Kiwana Butler.
Right, the two of you had a chance to go into the breakout room to talk about this further. Where are we, Mr. Asphalt?
We did, Your Honor, and I believe we are prepared to request that the court enter the consent judgment as originally indicated.
So, ma'am, you're gonna waive the right to have a hearing as to the amount and agree you owe $1,811.88, which you put on the record so far, and that's gonna be paid by October 15th, 2025. Is that correct?
Yes, that's correct.
All right, as long as you pay it by that date, it will be set aside. You failed to pay it, and they're gonna come in here and ask for a writ of eviction, giving you only 24 hours notice to move, okay?
Yes, I understand.
All right. Do you have any further questions, ma'am?
No, ma'am, I don't. All is well with you. Thank you.
I appreciate it. You'll have 3 business days from the date I sign this to petition the court to set it aside, okay?
Okay.
All right, you're all set, Ms. Butler. Have a good day.
Thank you, Judge. I believe that's all my cases.
Thank you. Have a good day, Mr. Asphalt. All right, the court will call the case of McKinley Properties LLC, the Villas versus Brandy Finley, case number 25C 3710.
Jillian Engen for plaintiff. Good afternoon, Your Honor.
Good afternoon, Ms. Engen. Long time no see. Well, that's partly because of me, because I got sick. But in any event. All right. This is Brandy Finley present.
Brandy Finley present.
Thank you. All right, we're here for this second hearing for non-payment of rent.
That is correct, Your Honor. We have a consent judgment. I can place terms on the record.
Thank you. You may proceed.
Thank you. This is a case for,
Well, before you do that, she filed a DC 539 form in this case. You heard that?
okay. I think that when Ms. Finley and I spoke, she told me that her application had been denied.
All right, is that correct, Ms. Finley?
Yes, that's correct.
All right, thank you. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,040.14. Court costs are $175 for a total of $1,215.14. The redemption date for this judgment is October 31st, 2025, and it says under further orders, this judgment will be set aside if paid in full on or before October 31st, 2025. And I did not discuss with Ms. Finley, I did not discuss that there would be no writ without a hearing. But Ms. Finley, if in the event it goes unpaid, then the court will not enter a judgment until after they have a hearing on this. So, and then Ms. Finley and I went over MCR 4.201J. She gave me permission to sign her name to this consent judgment, and she gave me her email so that she can be copied when this is submitted to the court.
Thank you, Ms. Finley. You understand you have a right to have a hearing as to the amount of rent that is owed?
Yes, I understand.
You're gonna not have that hearing, you're gonna waive that right, and you're gonna agree you owe $1,215.14 in total. All right. And
That's correct.
you pay that no later than October 31st, 2025, is that correct?
That's correct.
If it's paid, it'll be set aside. If it is not paid, then they can request a writ of eviction, giving you only 24 hours notice to move. You understand that?
Yes, I understand.
All right. We have 3 business days from the date I signed this petition the court to set it aside for a really good reason. You are all set. Have a good day.
You too.
Thank you. The court will call the case of McKinley Properties LLC, Spooner Cove versus Lavette White, Devon White, Aaron White. Case number 25C3682.
Jillian Engen for plaintiff.
Thank you. We're here today for this second hearing in this non-payment of rent case.
Your Honor, oh, I'm sorry. Your Honor, the parties have a consent judgment. I can place terms on the record.
You may proceed. You didn't have to ask.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $2,853. Court costs are $253 for a total of $3,106. This is entering as a default as to Javon and Aaron White, and as a consent as to Lavetta White, but the terms are the same. The redemption date for this judgment is October 31st, 2025. And then under further orders, it says this judgment will be set aside if paid in full or if defendants move out and turn in keys on or before October 31st, 2025. Ms. White and I went over MCR 4.201J. She gave me permission to sign her name to this consent judgment, and I have her email so that she can be copied when this is submitted to the court.
All right, ma'am, you have a right to have a hearing as to the amount that is owed. You understand that?
Yes.
You're gonna not have a hearing and waive that hearing and agree that you owe $3,106?
Yes.
Pay it by October 31st or move by that date, and this will be set aside. It won't be on your record. Fail to pay it, and it'll be on your record. And they will ask me to actually give you a writ of eviction, giving you only 24 hours notice to move. Do you understand that part?
Yes.
All right, you'll have 3 business days from the date I sign this. Petition the court to set it aside for a really good reason. You are all set, ma'am. Have a good day.
You as well. Thank you, Judge.
Thank you.
Bye.
Bye-bye. Court will call the case of McKinney Properties versus Juan Salas and Vincent Prosper, case number 25C3705.
Jillian Engen for plaintiff.
Neil Manis on behalf of Mr. Salas, Your Honor.
Thank you. We're here today for the second hearing in this particular matter. I do have an answer that was filed on behalf of the plaintiff.
Thank you, Your Honor. I spoke with Ms. Manis, and we are going to do some informal discovery. And so if Your Honor, and then also we are going to stipulate to an escrow order with rent in the amount of $1,279. And so if you would put it over for 2 weeks, I'm hoping we can, or we are both hoping that we can have some fruitful settlement discussions in the meantime.
So that council's not waiting all day like today, why don't we put it over to a 3 o'clock time period or a 3:15 instead of what we did today? Give me one moment. Let me look at that.
Thank you, Your Honor. Also, Your Honor, it's my understanding that we may be going back live in a few weeks, and so I think probably, Ms. Manis, correct me if this is not okay, but if Your Honor needed to put it over for like 3 weeks, if we are anticipating being back in person.
We won't be back in person, I don't think, until November.
Oh, okay.
Unless I can't take it anymore, and I'm getting very close to that, because today was pretty rough with all the people who didn't name themselves. It is, we actually, yeah. Right now, it's not until the week of November 17th.
Oh, okay. Then yeah, I would be fine with 3 p.m., Ms. Manis.
Okay, you're fine with that already, also, Ms. Manis? Are you okay with 3 p.m. also, Ms. Manis?
Yes, I'm sorry. I'm in the lobby, Your Honor. I'm trying not to have a lot of background noise for the court.
I saw you. So yes, all right. So yes, we'll see you on October the 8th at 3 p.m. Okay.
I'm sorry, Your Honor, could it be 2 weeks?
Oh, you said 2 weeks. My apologies. October 15th at 3 p.m. Okay.
Thank you.
Thank you,
Your Honor.
You're welcome. Have a good day. McKinley Properties LLC Roundtree versus Michael Linton, 25C 3676.
Jillian Engen for plaintiff.
Yes, this is Michael Lincoln.
Thank you. We're here for the second hearing in this non-payment of rent matter.
Yes, Your Honor, we have a consent judgment. I have rent to retain possession of $2,670.93. Court costs are $175 for a total of $2,845.93. The redemption date for this judgment is October 31st, 2025. And then under further orders, it states this judgment will be set aside if paid in full or if defendant moves out and turns in keys on or before October 31st, 2025. Mr. Linton and I went over MCR 4.201J. He gave me permission to sign his name to this consent judgment, and I have his email so that he can be copied when it's submitted to the court.
Thank you, Mr. Linton. We understand you have a right to have a hearing as to the amount of rent that is owed.
Yes.
You're going to waive your right to have a hearing and agree that you owe $2,845.93.
Yeah.
You're going to pay that no later than October 31st, 2025, or move by then.
Yes, ma'am.
And if you do either of those two things, it'll be set aside and not on your record. You fail to do either of those, they're gonna come back and ask for me to enter a writ of eviction, give you only 24 hours notice to move, meaning you have to do one or the other, okay?
Okay.
You'll have 3 business days from the date I sign this petition to court to set it aside for a really good reason. You're all set, sir. Have a great day.
You too.
Thank you. The court will call the case of McKinley Properties LLC, Aspen Chase versus Karina Damron Morin. Case number 25C 3695.
Jillian Engen for plaintiff.
I'm here, Karina Demmer.
Thank you. We're here for a second hearing in this non-payment of rent matter.
Yes, Your Honor, we have a consent judgment. I can place terms on the record. I have rent to retain possession of $3,523.59. Court costs are $175.
Before you proceed on this one, sorry to interrupt you.
Thank you.
But he did file a DC 539, and we need to address that before you proceed.
I think, Ms. Dameron, we spoke about this, right? And
Yes, and I still have not received anything back from them, so I'm not sure what's going on.
Your Honor, we talked about, I told Ms. Dameron that we could do a judgment today, or we could adjourn it for 2 weeks, and she decided that she wanted to do the judgment today.
And what's the balance again?
I have a total including court costs of $3,698.59.
Got it.
Thank you.
Right. So, ma'am, you understand you have a right to have a 2-week adjournment if your application is still pending, but you want to waive that right and a stay or an adjournment, however you want to term it, that you're going to waive that right and enter into an agreement today and not have this matter stayed?
Yes.
All right, you may proceed now. I just need to put that on the record.
Thank you, Your Honor.
Yeah.
Yeah, my notes are not always the best. Rent to retain possession is $3,523.59. Court costs are $175 for a total of $3,698.59. The redemption date for this judgment is October 31st, 2025. Under further orders, it states this judgment will be set aside if paid in full on or before October 31st, 2025. We went over MCR 4.201J, and Ms. Dameron gave me permission to sign her name to this consent judgment. She gave me her email so that she can be copied when I submit it to the court.
All right, Ms. Dameron, you have a right to have a hearing as to the amount that's owed. You're gonna agree that you owe $3,698.59, and you're not gonna have a hearing. Is that correct?
Yes.
You'll pay that no later than October 31st, 2025. If you do, it'll be set aside. If you fail to pay it, then they're gonna ask me for a writ of eviction, giving you only 24 hours notice to move. Do you understand that part?
Yes.
All right, you're all set. Have a good day. You'll have 3 business days from the date I sign this to petition the court to set it aside for a really good reason.
Thank you. You as well.
McKinley Properties LLC, Aspen Chase versus Bernita Dixon and Martika Anderson, case number 25C 3688.
Jillian Engen for plaintiff.
Vernita Anderson's here.
Very well done. Today's day and time scheduled for the second hearing in this non-payment of rent. There is no DC 539.
Thank you, Your Honor. I spoke with Ms. Vernita Anderson, thank you. And so she she's made multiple applications for rental assistance. She told me that she only caught the tail end of the rights video when she appeared at her first hearing. Your Honor, I am okay, given the amount of applications that she's put in. I can tell that she's actively working to get assistance. Your Honor, I'm okay with this getting adjourned to the 15th at 2 p.m.
October 15th, 2025. At, you say 2 p.m.?
Yeah, I thought that might be just the time.
No, you missed that in other words. All right, give me one moment. And that time is fine. Well, actually, yeah, that time is fine.
Okay.
Can I get it? Can the time be pushed back a little bit?
What do you mean by that? A little bit? What time are you talking exactly?
Can it be a later time?
Exactly what time, please?
3.
I would not object, Your Honor.
Like, I'm not gonna do 3 because that's my entry of order time. I can do 3:15.
Okay, that's fine.
All right, thank you. I'll see you at 3:15.
Okay,
Thank you, Your Honor.
Thank you.
Shannon Smith.
All right, thank you. We're here for the second hearing in this non-payment of rent. No DC 539.
Thank you, Your Honor. The parties reached a consent judgment. There's rent to retain possession of $2,243.66, court costs of $175 for a total of $2,418.66. The redemption date for this judgment is October 31st, 2025, and this judgment will be set aside if paid in full on or before October 31st, 2025. We went over MCR 4.201J, and Mr. Smith gave me his email address. He gave me permission to sign his name to this consent judgment so I can submit it to the court.
Wow. I'm hoping that he heard everything you said. 325 is what I got out of that. Anyway, so
Yes, I did.
you understand you have a right to have a hearing as to the amount of rent that is owed?
Yes, ma'am.
And you are going to waive that right, agree you owe $2,418.66?
Yes, ma'am.
Be paid no later than October 31st, 2025?
Yes, ma'am.
Paid, it'll be set aside. If you fail to pay it, then they're going to come back and ask me for a writ of eviction. It'll only give you 24 hours notice to move. You understand that?
Yes, ma'am.
Right, you'll have 3 business days from the date I sign this, which is likely to be today or tomorrow, to petition the court to set it aside for a really good reason. You are all set, sir. Have a good day.
You too. Thank you.
Thank you. All right, today's day and time schedule. I'm sorry. Court will call the case of Huron Heights and Huron Ridge versus Janita Sullivan, case number 25C 2923.
Good afternoon, Your Honor. Brittany Brownlick on behalf of the plaintiff.
Good afternoon.
Good afternoon,
Please state your name.
Johnny Sullivan.
Thank you. We're here today for an application and writ of eviction. Ms. Brownlee, have the two of you had a chance to talk?
Yes, I did speak with Ms. Sullivan. I did explain to her the situation and what's happening. My client is still requesting to proceed with the writ. There has only been $560 paid towards the judgment. Total judgment amount originally was $1,290.94, issued back on August 13th. So there's still a balance on that. There is also September and October rent and utilities that have accumulated since then as well.
Thank you. So Ms. Sullivan, you're here because back on August 13th, I entered a judgment for $1,290.94. I gave you until August the 25th to pay that, so you had 12 days. The only payment you made was $560. I set this on my docket because it's below my threshold, and it sounds like you haven't paid the judgment off yet.
I was in a hospital that time.
All right.
I was fighting for my life, but I've been searching for help. I got two people trying to help me. My DHS worker. I just turned my paper in Friday, so I'm waiting on them.
Ma'am, that was back in August. We're here now in October, and you still haven't paid your rent. They're asking for a writ of eviction. And unfortunately,
Okay.
I'm glad that you are alive and everything worked out in terms of that, but I can't give you additional time. They want a writ of eviction. That will give you 24 hours notice to move.
So what that mean? I have to move now?
Yes, you will have 24 hours from the date that I sign this, and I'm about to sign it right now. So once I sign this, they're going to give you 24 hours notice to move when they put this on your door, which is likely to be tomorrow.
I don't have nowhere to go. I was gonna pay the rent.
I'm sorry?
I know that I'm supposed to pay in August.
All right.
And I don't have nowhere to go.
Miss Amy, are you available to talk to her?
Good afternoon, Your Honor. I am available and I would like to meet with her. Thank you.
We'll put you two in a breakout room. But as far as the writ is concerned, I'm signing the writ today. Okay?
Okay.
All right. Thank you.
Thank you, Judge.
The court will call the matter of Huron Heights and Huron Ridge versus Erica Floyd, 25C 2914.
Judge Brittany Brownlick on behalf of the plaintiff.
Erica Floyd present. I know who that is. You don't have to worry about that person. That's a continuation hearing. Okay. Well, maybe not, because he's in here. All right, the phone number of 0827 that ends in 0827. Please unmute your device and tell me your first and last name.
Wait a minute.
Can you tell me your first and last name?
Yes, hello.
Can you please tell me?
Rhonda Brooks.
Thank you.
Thank you.
All right, we may or may not be able to make it to November with not being in person because people just won't do what they're asked to do, which is to label themselves so we know who you are, or unmute when you're asked to unmute. All right, Ms. Brownlick, the Erica Floyd is not present.
I would still request, my client is still requesting a writ to be signed in this case. The judgment was entered August 13th for $1,311. There was $1,100 paid. That's all that's been paid so far. That was paid on September 5th. There have been additional rent and fees since then, with a balance on the account as of now. So we would still request that the writ be filed since the judgment amount has not been paid off.
What is the total balance right now?
Total balance, let's see, I don't know if there's anything. Sorry, this doesn't include the October. So with October, it's $789.
All right, they failed to appear here, and I will grant the writ under those conditions.
Thank you, Judge.
You're welcome. We'll call the matter of Huron Heights and Huron Ridge versus Kiera Harris, case number 25C 2916.
Brittany Brownlick on behalf of the plaintiff.
Is Kiera Harris or anyone from 1383 Concord present? Defendants failed to appear.
Judge, in this case, there has not been any money paid at all towards the judgment amount. The judgment was entered back on August 13th in the amount of $539.63. As of today, the balance on the ledger is $963.22.
Writ is granted.
Thank you.
Rhonda Brooks.
All right. Please, counsel, you may proceed.
Thank you, Your Honor. So I did have a chance to speak with Ms. Brooks, and we've agreed to enter into a possession only consent judgment where Ms. Brooks has agreed to pay the rent retain of $3,480.23, costs of $215, total of $3,695.23. Ms. Brooks has agreed to get that balance paid by the 17th of October. Under the further orders, we would be agreeing to set aside the default judgment that was entered back on August 28th, 2025. And additionally, it would state that Ms. Brooks was approved for assistance through Hawk, and once those payments have been received by my client, they'll be applied towards the balance. And then, Your Honor, Ms. Brooks advised me that there was an escrow entered with the court. Do you have record of that?
I have $711 in escrow.
Thank you, Your Honor. And then we have agreed that escrow would be released to the plaintiff.
Thank you. Ms. Brooks, you understand you have a right to have a hearing as to the amount of rent that's owed?
Yes.
And you are going to agree that you owe $3,695.23 that you're going to pay according to the terms that Mr. Graybat just placed on the record?
Yes.
All right. As long as you pay that, then you will not have a judgment on your record. And I think you said you're agreeing to set aside one from August 20th, 2025 as well. Is that correct?
August 28th, Your Honor.
August 28th. All right. I will sign this agreement, ma'am. You'll have 3 business days from the date I sign it to petition the court to set it aside for a really good reason. If you fail to pay, you'll only have 24 hours notice to move. You understand that part?
Yes.
All right, thank you.
Thank you, Your Honor.
You're all set. Is the case of Lakeview versus Stephanie Gordon going to be a trial?
We have an agreement, Your Honor.
All right. What we'll call the case of Lakeview versus Stephanie Gordon, 25C 3057.
Raymond Gravitt for the plaintiff.
Stephanie Gordon.
Thank you. All right. You may proceed with the agreement.
Thank you, Your Honor. So we have agreed to enter into a conditional dismissal for this matter. Rent retain of $4,187.17, cost of $175 for a total of $4,362.17. Ms. Gordon's agreed to have that balance paid or vacate by October 20th, 2025.
You understand you have a right to have a hearing as to the amount that's owed?
Yes.
You're gonna waive any right to have that hearing and agree you owe $4,362.17? Hello?
Um, no, I don't. I guess that's where I get confused at. I just want it to go away, but I guess the conditional dismissal, they can potentially come at me for the 4,300. At that time, would I be able to dispute the amount?
Ma'am, this is the amount that you would have to pay in order to be able to keep the apartment.
Okay. So I agree.
Unless you don't agree that you owe that amount, and then you can have a hearing. Do you want to have a hearing or not?
You know what? Actually, I would like a hearing.
What is your dispute over?
I believe that the landlord is responsible for some of the water.
Okay. All right. Fine. You're gonna be waiting for a while. I'm not getting ready to do another hearing right now. I have, I think, 3 hearings ahead of yours. Okay?
Your Honor, given that, I wouldn't mind putting this out because I know it is late, to next available for the court if that would work better for you.
Yeah, October 15th. Did you guys talk about the water issue, Mr. Bribet, and you can't agree?
That's correct, Your Honor. It's my client's position that there was no issues with the water. They checked the meter several times. They couldn't find any issues. So from what they can determine that the water is just from usage.
Alright. So what I'm gonna do is, I'm not gonna go October 15th. I'm gonna go to October the 8th. So are you available next week at 3:30 p.m.?
Yes, I am.
Yes, Your Honor, I should.
Or do you want me to put it go to the 15th? I can do that.
I can do either or, Your Honor.
All right. We'll stick with the October the 8th at 3:30 p.m. then, okay?
Thank you, Judge.
See you then.
Thank you.
You're welcome. All right, the court will call the case of Lakeview versus Latoya Brooks, 25C 3055.
Raymond Gravitt for the plaintiff. And Your Honor, I do believe this is a motion for entry of an order of eviction. We would be withdrawing the request for the writ.
The request for the writ is withdrawn.
Thank you, Your Honor.
You're welcome.
Have a good day.
Thank you, you too.
Thank you.
Court will call the case of McKinley Properties versus Raven Nobles, case number 25C 3700.
Jillian Engen for plaintiff.
Hello, I'm here, Raven Nobles.
All right, thank you. Today's the time scheduled for the second hearing in this matter.
Your Honor, Ms. Nobles is working with Peace Neighborhood. She's going to call them tomorrow. If you would adjourn this, I think to the 15th.
October 15th, 2025 at, one moment. We might as well do 2 p.m.
Okay.
Thank you.
Thank you.
Thank you.
You're welcome. Have a good day.
All right, you too.
Do my best. McKinley Properties LLC Schooner Co. versus Sharon Blackman and Adriana Blackman, case number 25C 3683.
Jillian Engen for plaintiff.
I'm sorry, Sharon Blackman, Adriana Blackman.
Thank you. All right, we're here today for the second hearing in this non-payment.
Your Honor, The parties have reached a consent judgment. I have rent to retain possession of $1,482. Court costs are $214 for a total of $1,696. The redemption date is October 31st, 2025, and this judgment will be set aside if paid in full on or before October 31st, 2025. I went over MCR 4.201J with Ms. Blackman and Ms. Blackman, and they gave me permission to sign their name to this consent judgment. I have an email that I can send this to when it's submitted to the court.
Thank you. All right, everybody on the call, should understand you have a right to have a hearing as to the amount of rent that is due. I'm trying to expedite things today because it's gonna be a long day otherwise. I think I got about 17 cases to get through before we even get to our hearings. So, yes, so please, when you get on, I'm just gonna ask you, do you realize you have a right to have a hearing, okay?
Yeah.
All right, so, and you're gonna agree that you owe $1,696 and you're gonna pay that by the date that she said?
Yes.
And if you do, it'll be set aside. You fail to, they're gonna give you 24 hours notice to move. So if anybody fails to comply with the agreement, you only get 24 hours notice to move. I'm gonna ask you if you heard my spiel. If you did, then you can say yes.
Yes, I did.
All right, you're all set. You'll have 3 business days from the date that I sign this, which is likely to be tomorrow, to petition the court to set it aside. You're all set. I'm sorry?
Hey, thank you. Have a good one.
Thank you. I'll do my best. Bye. One moment, everybody.
Roosevelt Boyd.
All right. Mr. Boyd, I think Mr. Friedman, given the timing that we have today, is asking to move this to the 8th instead of completing the hearing today. Is that what
I'm not sure if I think you said you had 17 hearings before you started, or 17 more before you started the hearings?
That's correct.
Yeah, okay.
That's about right. It might be more. I'm not sure.
Okay, I can't stay that long, and the 8th didn't sound like it was going to be so crazy.
Yeah. When I originally, anyway. Mr. Boyd, do you want to, are you okay with adjourning it for 1 week, sir?
I ain't got no problem with that, but I would like to get back in my apartment. That's what I need to do. I'm on a civil standby until I can prove that I'm only one on the lease and only one live there. I've been out of my house almost 3 weeks now. I want to go home.
Sir, you're talking about a different case. That's not this case. You're talking about your criminal case, and we're not here for that.
But you judge on that case too, though.
That doesn't matter.
Okay.
All right. See, no matter what the decision is today, it will not affect your criminal case, okay? And you and I can have no communications today about your criminal case because the prosecutor's not here, and it's considered ex parte communications. Are we clear?
Yes, ma'am.
All right. So I'll see you back here on October 8th.
Okay.
And that'll be at, what time did I did one at 4, right?
Yeah, you did that. No, that's on the 15th, Your Honor.
Okay.
All
right.
Hearing for Lakeview is at 3:30 on the 8th.
All right, I'll do this one at 4 p.m., Mr. Friedman.
Thank you.
So October 8th at 4 p.m., sir, okay?
I think he's getting up to leave.
Did you hear the time, Mr. Boyd? 4 p.m. All right, thank you. Thank you, sir. All right.
Thank you.
Thank you. Thank you.
I'd say have a good rest of your day, but I don't think that's going to work one way or the other.
But I appreciate it. It could get worse. So let's give it whatever goodness we can.
All right. Thank you.
McKinley Properties LLC, Schooner Cove versus Brenda Hollander, case number 25C 3680.
Jillian Engen for plaintiff.
Brenda Hollander, please unmute your device. State your name.
Brenda Hollander.
Thank you. Did you hear my spiel earlier, ma'am?
Yes.
All right, thank you.
Your Honor, we're adjourning this case to the 15th, hopefully.
All right, so the spill didn't matter. All right, October 15th at 2 p.m.
2 o'clock?
Yes, why are we adjourning? How much is the outstanding balance right now? Is it still?
I have a balance including court costs and October rent of $3,755.92.
All right.
Ms. Hollander is working with SER and Hawk, she said that they have some senior funding. And so she's hoping to be able to to qualify for that.
Thank you. All right. Good luck. Okay, Ms. Hollander?
Okay, so October 15th at 2 o'clock.
Yes, it is. Thank you. See you then. Thank you. All right. Thank you. Mr. Tempo? I don't know if you were here, but your hearing's not happening today. Your attorney just adjourned that till next week. Unless you want to be here until 8 o'clock at night, you probably should go with him. Can't hear you anyway. McKinley Properties LLC, Aspen Chase versus Tylese Gardner, 25C 3698.
Jillian Ingen for plaintiff.
Elise Gardner.
Thank you. We're here for this second hearing in this non-payment of rent matter.
Yes, Your Honor. Ms. Gardner told me that she submitted a DC 539. She has a pending SCR application. Her balance is $1,201.48. And so if you could adjourn this to October 15th at 2:00 p.m., that would be wonderful.
Done. October 15th, 2025 at 2 p.m. We'll see you then, ma'am. Make sure you keep all your appointments, okay?
Okay, thank you. Have a great day.
I appreciate it. Ms. Hollander, you can hang up, ma'am.
Okay, I didn't know. Okay, thank you.
Bye-bye.
Bye-bye.
McKinley Properties LLC, The Villas versus Schuler Bradley, case number 25C 3706.
Jillian Ingen for plaintiff.
Skylar Bradley.
Skylar?
Yep, Skylar.
Oh, wow. Okay. Thank you. I'm going to write that down because I will not remember that next week either. All right. We're here for the second hearing in this non-payment of rent matter.
Yes, Your Honor. Mr. Bradley told me that he had an application with MI Bridges that he submitted a DC 539 form to the court. His current balance is $1,755.33. If Your Honor would adjourn this to October 15th at 2 p.m., that would be wonderful.
Granted. See you then, October 15th at 2 p.m., sir.
Okay.
You have a question? If there's something you can.
Just one quick question. I got about $655. That's including October rent. So if I pay that $655, is everything gonna be included, or you want the whole? You know what I'm saying?
I don't think he's talking to me.
Mr. Bradley, I have your balance. It includes October rent and court costs at $1,755.33. If that amount is paid in full, if you get to a zero balance at any point, then we'll submit a dismissal.
Okay, but not like the 660 or whatever, the 670, like the stuff from like before today, because I know October posted today.
No.
Yes.
It will not be dismissed unless you pay the full balance that she just gave you, sir.
All right, thank you.
You're welcome.
Thank you.
McKinley Properties LLC, Aspen Chase versus Maria Rodriguez, case number 25C 3702.
Jillian Ingen for plaintiff.
Maria Rodriguez.
Thank you. All right, now we're here in the second hearing for non-payment of rent.
Yes, Your Honor. And Ms. Rodriguez and I had the chance to speak, but we did get interrupted due to connectivity issues. But I think that we have an agreement. I just would need to discuss MCR 4.201J with her, and I would need her to call my office to give me her email address. So I can put the terms on the record. The rent to retain possession is $1,869.58. Court costs are $175 for a total of $2,044.58. The redemption date for this judgment would be October 31st, 2025. It would be set aside if paid in full on or before October 31st, 2025. And Ms. Rodriguez, under MCR 4.201J, you have 3 business days to petition the court to set aside the consent judgment for good cause. The judge is the one who determines what good cause is, but generally it's that you gave up rights you didn't know you had, or you misunderstood some of the terms of the order. And I'm going to sign my name to this consent judgment. Do I have permission to sign your name to this consent judgment?
Yes, ma'am, you do. Thank you.
Thank you.
All right, ma'am, did you hear my spiel when I gave it earlier?
I did.
All right. And so you understand that you're gonna be paying the $2,044.58 according to the terms she just placed on the record, correct?
That is correct, yes, ma'am.
All right, you have 3 business days from the date I sign this, likely tomorrow, to request that it be set aside for a good reason. Have a good day.
Likewise, thank you kindly.
Thank you. Code call the matter of McKinley Properties LLC Schooner Cove versus Korea Hendricks Owusu, case number 25C 3687.
Jillian Engen for plaintiff.
Korea Hendricks.
Thank you. Today's day and time scheduled for the second hearing in this case.
Yes, Your Honor, and my eyes stopped working. I'm gonna find this one. I can't read.
Well, while you look that up, Ms.
I found it.
Hendricks Owusu, did you hear the spiel that I gave earlier?
What spill? What do
Okay.
you mean the spill?
Never mind. I will give it to you when the time comes. Go ahead, Ms. Engen.
Your Honor, Ms. Hendricks has an application with Friends Indeed, and I don't think that she submitted a DC 539, Your Honor, but I am okay to adjourn it to the 15th at 2 p.m.
All right, adjourn October 15th, 2025 at 2 p.m. What is our balance, please?
I have a balance including court costs and October rent of $3,933.
Thank you. All right, ma'am. I'm going to adjourn this until then. You need to keep your appointments with Hawk or whoever you have your appointments with. Okay?
Okay,
You're all set. Have a good day.
thank you and God bless you.
Thank you. I appreciate that. McKinley Properties LLC Schooner Cove versus Tracy Ward, case number 25C 3681.
Jillian Engen for plaintiff.
Hello.
Please state your name for me.
Tracy Ward.
Thank you. All right, this second hearing in this non-payment of rent matter.
Your Honor, the parties were unable to concur on the amount owed. Ms. Ward is contesting the amount claimed. I sent her a ledger so that she can look through and make sure that, I send it via email, so she can look through and make sure that all the payments she's made are reflected on the ledger. So if Your Honor would put this over to the 15th at 2 p.m., I'm hoping that she can get back to me with any discrepancy and we can resolve it.
Is that correct, Ms. Ward? You're going to look at that ledger?
Yes, ma'am.
All right, thank you. I'll put this over to October 15th, 2025 at 2 p.m. Hopefully you get a chance to look at the ledger. You might want to call them before the day of court because it helps to expedite things if you're ready to go. Like, so if you walked in here and you were ready to go, she could tell us before, if she got here first and you got here first, she could say, I'm ready to go on that one, so we don't have to actually go into the breakout room. So it does expedite stuff, okay?
Okay.
All right, thank you. Have a good day. See you on October 15th.
All right. You too. Bye.
Bye-bye. McKinley Properties LLC, Schooner Cove versus Chantel Reese, case number 25C 3686.
Jillian Engen for plaintiff.
Chantel Reese.
Thank you. We're here for the second hearing in this non-payment of rent matter.
Yes.
Yes, Your Honor. Ms. Reese has an application in with Hawk. I think she's going to work on some other applications for rental assistance. I have a balance including October rent and court costs of $2,096. If you would adjourn this to October 15th at 2 p.m., that would be wonderful.
When is her appointment with Hawk?
I actually had the interview yesterday. I also submitted a SCR. And I submitted all documents and I'm waiting to hear back.
All right. Then I will see you here on October 15th, 2025 at, well, I'm sure you'll see me at 2 and I'll probably see you, but we may not talk until later, but see you on October 15th, okay?
Okay, not too late.
You know, I wish I could do better.
I'm like sitting up here like, oh my God.
I could tell you were doing
I'm
everything.
like,
You go
it's
like
been a
this.
long day. I've been
Ms. Reese, it looks how we all feel. We're all just, we're there with you.
I understand, but I'm doing the best that I can. I truly.
Okay, I understand.
Thank
Have a good day.
Have a good day.
Bye-bye.
All right, the court will call the case of McKinley Properties LLC, Schooner Cove versus Esther Glaze and Linda Glaze, case number 25C 3677.
Jillian Engen for plaintiff. And Ms. Glaze, if you hit *6 to unmute and state your name.
This is Esther Glaze.
Thank you. We're here for this second hearing in this non-payment of rent matter.
Yes, Your
Yes.
Honor. Ms. Glaze has an SCR application in, and I think she submitted a DC 539 form to the court. I have a balance, including court costs and October rent, of $3,285.44. If you would adjourn this to October 15th at 2 p.m., that would be wonderful.
Thank you. You did, and submit that form, or we'll adjourn it, and make sure you keep your appointments, ma'am, okay?
Thank you. I will.
Thank you. Take care of yourself. Thank you for your patience
Thank
today.
you. You also.
All right.
Bye-bye.
McKinley Properties LLC, The Villas versus Mamadou Mbanjo, case number 25C 3707.
Jillian Engen for plaintiff.
Mamadou Mbengue.
Thank you. We're here for second hearing in this non-payment of rent matter.
Yes, Your Honor, and the parties have a consent judgment. There's rent to retain possession of $3,261.40. Court costs are $175 for a total of $3,436.40. The redemption date for this judgment is October 31st, 2025, and this judgment will be set aside if paid in full honor before October 31st, 2025. Mr. Mbengue and I discussed MCR 4.201J. He gave me permission to sign his name to this consent judgment, and I have his email so I can copy him when it gets submitted to the court.
Mr. Mbanjo, as I said earlier, you've been here about 6 times, so you do understand you have a right to have a hearing as to the amount of rent that is owed. Is that correct?
Yes.
But you are going to waive your right to have that hearing, and you're going to agree that you owe $3,436.40?
Yes.
And you're going to pay that no later than October 31st, 2025, correct?
Yes.
As long as you paid it, it will be set aside and you won't have the judgment on your record. If you do not pay it, then they're going to come in here and ask me for a writ that will give you only 24 hours notice to move. You understand that part?
Yeah, I do.
All right. Then I will sign this, and you'll have 3 business days from the date I sign it to petition the court to set it aside for a really good reason. You're all set, Mr. Mbanjo.
Thank you. Have a good day.
Thank you. You too. The court will call the case of AMK Properties versus Rosemary Brown, case number 25C 3164.
Jillian Engen for plaintiff.
Ms. Rosemary Brown, please unmute your device and state your name. Ms. Rosemary Brown, please unmute your device and state your name. Otherwise, I'm going to handle this case without you, because if you don't unmute, then you're considered not here. All right, Ms. Engen, Ms. Rosemary Brown is not answering. And this is an application for an eviction in this particular case?
Yes, Your Honor, and I spoke with Ms. Brown and her son who is with her. There's $285.41 remaining on the judgment. There was a check to be sent from St. Vincent de Paul, and St. Vincent de Paul apparently sent it in the beginning of September. It's in the amount of $300. It would cover the amount remaining on the judgment regardless. They are planning on making a payment in the next couple of days that would cover the amount remaining on the judgment. Your Honor, if you would adjourn this to the 8th at, I guess it would be 3 p.m., then I anticipate that we would submit a certificate of satisfied judgment.
Right. So, Ms. Rosemary Brown, I see you unmuted now. Can you state your name?
Rosemary Brown.
Thank you. And you're going to submit payment on your rent between now and next week, correct?
Yes, correct.
I'm going to adjourn this to October 8th at 3 o'clock p.m. for you to get this done, so I don't have to get your rent, okay?
Thank you very much.
Thank you. You're all set. Have a good day.
Have a good day.
Okay. Thank you.
Okay.
Court will call the case of McKinley Properties LLC, Schooner Cove versus Alyssa Estelle, case number 25C 3679.
Jillian Engen for plaintiff.
Alyssa Estelle. Thank you. We're here for this second hearing in this non-payment of rent matter.
That is correct, Your Honor. I have a consent judgment. Rent to retain possession is $4,357.12. Court costs are $175 for a total of $4,532.12. The redemption date for this judgment is October 31st, 2025. It will be set aside if paid in full honor before the 31st. We went over MCR 4.201J, and Ms. Estelle gave me permission to sign her name to this consent judgment. I have her email. I'm going to copy her when it's submitted to the court.
Thank you, Mrs. Stell. Did you hear my spiel when I gave it out earlier?
Yes, ma'am, I did.
All right, so, you understand, as long as you pay this by October 31st, then it'll be set aside. You fail to, they're gonna ask me to issue a writ, giving you only 24 hours notice to move, right?
Yes, ma'am.
And you'll have 3 business days from the date I sign this petition to court to set it aside for a really good reason. And that is your agreement today, correct?
Yes, ma'am.
Great, you're all set. Thank you for your patience today. I hope you have a better day, ma'am.
Hope yours gets better.
Thank you. I appreciate it.
Bye.
The court will call the case of McKinley Properties LLC Schooner Co. versus Julie Bonfamichan, case number 25C3685.
Jillian Engen for plaintiff. Your Honor, plaintiff is requesting a default judgment. I can place terms on the record.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, nothing but the truth? So help you God.
I do.
Thank you. You may proceed.
Thank you. There's rent to retain possession of $4,114. Court costs of $175 for a total of $4,289. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Granted, that's all of that, with the redemption amount being the same.
Thank you.
We'll call the matter of McKinley Properties LLC, Aspen Chase versus Robert Miles, case number 25C3697.
Jillian Engen for plaintiff. Your Honor, plaintiff is moving for a default judgment. I can place terms on the record.
You may proceed.
Thank you. There is rent to retain possession of $3,328.38. Court costs are $175 for a total of $3,503.38. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Granted, as to all of that, with the redemption amount of the same.
Thank you, Your Honor.
That's it for us today. All right. Have a good day.
Thank you. You too.
It's
gonna be nice when you leave. It's gonna feel really good.
a while from now. So
Yeah.
the
All right.
court will recall the case of David Wallow versus Michael Metcalf. Case number 25C2952.
Hello, Your Honor.
Please state your names.
My name is Michael Metcalf.
Mr. Wallow, please unmute your device and state your name again. Mr. Wallow, please unmute your device first.
Wait a minute, David Wallow.
Thank you, Mr. Wallow. All right, I'm gonna swear you all in
Welcome.
again. It's been so long ago. Please raise your hand. Both of you raise your right hand. Mr. Wallow, please raise your right hand.
Oh,
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
yes, I do, Ben.
You can look the lawyer hand. Mr. Metcalf, you?
Yes, ma'am, I do.
Thank you. You both may lower your hands. All right. So,
Oh, I apologize.
Mr. Wallow, this is your case. So the way it works is you start first. Okay? So, Mr. Wallow,
Yes, ma'am.
you filed this action here before the court, asking that the court evict Mr. Metcalf from your home.
Yeah, he supposedly wanted to rent a room from me because his mother lives here too. I got 2 rooms. I sort of rent out to roommates because I don't have enough money to pay my bills. And when these people don't pay, I'm getting behind on my bills.
Mr. Wallow. So first of all,
Yes.
so both of you, here are the rules. If it's a
Yes,
yes,
ma'am.
if it's a yes or no question, please answer with the yes or no. Okay? If it
Yes.
requires more explanation, then you can give more explanation. If I ask for that, okay? If you don't understand the question, ask me to rephrase it. If you didn't hear the question, ask for me to repeat it.
Okay.
Okay?
Okay.
So You filed an action to terminate the tenancy, is that correct?
Yes,
And you indicated that he's in possession of the basement room?
yeah, I have a nice room in the basement with carpet, his own bathroom and everything. Finished basement, finished room.
Does it have an egress?
Say that again, ma'am.
Does it have an egress?
Yes, it does, ma'am. It does have an egress.
What's the egress?
That's the escape window if there's a fire. You gotta have a window to escape out of. It opens, I have to open up 5 feet, which it does. Because that a regular company put it in.
All right.
Because in the basement, all you got those little windows, and you gotta have one window where the person can escape when there's a fire.
Okay, sir, I said okay.
And so I
Okay.
put that in.
So you can stop repeating that, okay? All right.
Okay.
In your request to terminate his tenancy, you indicated it's for non-payment of rent.
Right.
How much rent are you claiming he owes you?
Well, he had some company pay his rent for a year.
Sir,
Yes.
the question is simple. How much rent are you claiming that he still owes you? And I just want a number.
Oh, just 1,000, 2 months. But I want him out of here, my house. Because my girlfriend, she's scared of him and she had to move. She couldn't take it no more. Because he is.
All right. So, sir, now you're saying you want him out, so you're not, you filed a termination of tenancy. And initially you were saying you wanted him out because of rent, and now you're saying you just want to terminate the tenancy?
Yes, I don't care about the rent right now. I just want him out of my house. Because I'm not in too good a shape. And he scares me to death sometimes.
And you indicated that there is a lease, correct?
Yeah, he wrote it up. I always say the people write up their own leases when they move in here for a roommate, and that way there's no questions asked.
And you
It's in his handwriting. You should have the papers. You should have the papers of that section in there.
And in this lease is basically 2 paragraphs. I, Michael Thorne Metcalf, hereby agree that I'm renting a 1-bedroom and bath, including TV and furnishings at the address. The monthly rent is $500.
Yeah.
Utilities, rent is due the first of the month. Is that correct?
Yes, ma'am.
And so
That's correct.
is a month-to-month lease?
Yes, that's what he wanted.
Okay, thank you. All right. Mr. Metcalf,
Yes, ma'am.
what is your dispute with the facts? So, first of all, sir, do you acknowledge that he served you with the notice to quit? Let me
There's
finish
some
my
inaccuracy
question.
on the date that.
Let me finish my question.
Yes, ma'am.
That he served you with the notice to quit on June 3rd, 2024?
I couldn't give you a specific date that the document would have been received by me, but I will say that I think some of the dates on that document were inaccurate. If you just look at them, and just for the record's sake, I think the year or something on there was not.
Right, it says June 3rd, 2024.
Right, and the month, it was like the month and the year, and it was just not the right date that was listed on there. I remember thinking that, so.
Right, the move date says June 4th of 2024.
Yeah. And, well, I'll wait for you to.
Go ahead. What would you like to say, sir?
Um, I made a payment of $300 to him, I think just 2 weeks ago. And while the first avenue of employment that I had didn't pan out for me, I have been working like as a privately hired by a family on the north side of town, by the golf course, just helping them do home reno and landscaping and stuff. So I have been trying to work regularly and was hoping to make another payment to him by the end of this week, or well, by the end of the weekend, really, because I work for them largely on the weekends and in the evenings.
I don't know if you indicated whether or not, or you heard whether or not he said he is not trying to get rent from you anymore. He wants you to leave.
I did hear that, but that was, that to me, that's news to me, because our understanding when I gave him the payment was that I was trying to make payments in excess of what I owed for rent to try and start paying back some of what I owed him. We had that discussion, and although there is nothing in writing, but we did talk about it. And I just want to comment and say that, he's him claiming that his girlfriend moved out because she's scared of me. Like she moved out because she's in hospice and went to a convalescent home. So I feel like he's just trying to misrepresent things a little bit to make it seem like that would be a, suitable reason to kind of usher me out of here, which, I take offense to that, because I've always been nice to Dave. I never invade his personal space. His bedroom and stuff, is his, and he's explosive with his like anger, but like I do my best to keep the kitchen clean and communal areas like that, free of debris and whatnot. And it just, I don't know, that seemed wrong. So I just felt like I needed to say something.
All right, so is there anything else that either one of you would like to say?
Just that Your Honor, if this is going to result in, me being told that I've got to leave, I just hope that I can have a little bit of time, because, knowing whether I'm getting money together for him or knowing whether I'm getting it together to try and find, to make a down payment on a lease or just to get a room somewhere else. Like, if it's like, you got to be out tomorrow, I have no idea what I'm going to do. So I will say that.
Well, this is what I will say to you right now, is that if he were to win, you get 10 days to move. Okay, that's the way it works.
I'm sorry, could you repeat that? That just it was a little muffled.
You would get 10 days to move if he were to win. Okay.
Okay. All right.
But this is the other problem. Mr. Wallow, I need for you to listen to me very closely. So you
say that again, ma'am.
I need for you to listen to me very closely.
Okay.
You filed an action to terminate well, let me ask one before I make my ruling. Mr. Metcalf, did you say you paid him some money since this matter was filed?
I did. I gave him $300 out of I worked at a restaurant for 2 weeks. It unfortunately was not a good fit, but I took the money from that paycheck and gave him the majority of that 2-week paycheck. And as I said, I've been trying to, like, I just paid my phone bill and any cash that I have.
Mr. Metcalf?
I'm sorry. Yes, ma'am. Yes.
Did you pay him?
I answered your question. I did, yes. Although I did, yes.
Mr. Wallow, did you accept $300 from him, sir?
Yes, I did, but it's in my safe because rent's $500. I did tell him that.
So, Mr. Metcalf, here's the thing. You filed an action to terminate his tenancy. Once you file an action to terminate tenancy, you can't accept rent. If you accept rent, it voids the actual termination for tenancy. So you got to decide which one you're doing. Either you
That's why I kept it in my safe.
Stop talking over me.
Okay, I'm sorry.
You need to decide whether you are going to accept money or you just want him out.
I want him out.
Well, you can't do that now because you've already voided this particular case. So if you file another case, first of all, it has to be because you don't have a lease. I can't give you legal advice. You have to file it properly. You didn't file it properly for so many reasons. You need to listen so you can try to get it right next time. So listen, okay?
Well, ma'am, I'm 76 and I'm in bad condition. I don't
If
understand
you
half
don't
this.
listen, he's going to be in your house forever. So you can be 85. You still have to listen.
I don't think I'll live that long, but okay.
Or you cannot listen. And I can just rule that you
I
will.
am listening to you, my honor.
Okay. So you got to file an action to terminate the tenancy based on the fact that you just want him out. And you got to file the paperwork properly. Your notice to quit that you served him, first of all, has the wrong year that you served him on, which we can rectify by you saying what year you served him on. We can fix that. But you can't give him a notice to move. If you serve it on June 3rd, 2025, you can't give him a notice to move by June 4th, 2025. You got to write the proper notice on there. He gets 30 days.
Yes.
So you got to do that properly. And then in your complaint, you got to say that you just want him to move because he doesn't have a lease. You can't say that you want to accept rent. You said this was for rent, and then you accepted rent from him. So you void the termination. You now have to start a new case. And in addition to that, what makes it so clear that that's what you did is you came back here on August 27th and you asked me to adjourn it to September 24 so he could pay. And then he paid. And so now you can't just file this action this way. You got to start over.
Oh, bother. Ma'am, I'm not too smart and I don't know that I've never done this before. And I'm not very smart and I'm doing the best I can with what I got. Girlfriend died 2 years ago, my other girlfriend. Now I got a new one. She won't live here. She moved over there. Her clothes and everything are still here. I have to take her clothes over and shoot.
I'm really sorry about all of that. And I'm really sorry that you are where you are, but I can't not.
I can't help it.
You have to follow the law and you have to listen if you want to get it right.
In other words, you're trying to say I'm dumb, right?
Oh, God.
All
right.
Because, ma'am, I did the best I could.
Okay.
I'm not on D's and E's all through school. I've had 2 head-on injuries, and I'm doing the best I can. I got to have rent every month so I can pay my bills. That's why I got 2 roommates.
I understand.
Okay.
And I'm not saying any of that. I'm just telling you what the law requires. That's it. So if you didn't listen, I can't help you any further, sir. Good luck to both of you.